Good afternoon, everyone. My name is Christina from Chicago Title. Thank you so much for this opportunity to present to you your next speaker. Trevor has over 45 years worth of experience in the state litigation and frequent speaker in the subject of estate law. Sorry, guys. Uh, for, um, 45 years experience and frequent speaker on the subject of estate law with various groups. He has also been featured in innumerable newspapers and media appearances. During his free time, he loves to travel and has been to 131 countries, and I'm sure as soon as the travel restrictions are lifted, he'll be adding to that list. Please welcome Trevor. Trevor, you're on mute. You're on mute.
Unmute. Hi, can everybody hear me? Great. Hello again. It's great to be with you. Thank you very much for the introduction, Christina. This is the 23rd year that I have been talking to you at your conventions and various subgroups and so forth. I've done a cruise with you to California. I've been around a long time. I've been writing for the Scrivener that long. I've got, I think, 110 articles I've written for the Scrivener. So it's been a great relationship. And this is one of my favorite topics, undue influence. The title is The Good, the Bad, and the Ugly, and that came directly from Wayne Braid, legendary director. And we were kicking around titles, and he thought that would be a good one. And I followed it up by sending him a painting of the Hollywood Theater in Kitsilano, a rather iconic theater that I went to as a child. And it just so happens that in 1995, when I commissioned the painting, I had on the marquee, The Good, the Bad, and the Ugly. So let's pretend any serious offers will be considered. It's for sale. John Lennon behind me joins us. He's by the same artist, Paul Yeguartua. And I commissioned John, I think, in 2002. So I'm showing my age here, being a John Lennon fan. Undue influence is a great topic. We're going to call the good being you being able to discern it and try and prevent it, the bad being when you don't, and the ugly being the virus of estate litigation itself, undue influence. Because undue influence is a type of constructive fraud. It's generally speaking perpetrated on vulnerable adults, the seniors. We all know who we're talking about here. We've all seen vulnerable people. We probably have them in our family at some point. And they are, just as it sounds, particularly vulnerable to the undue influence of another person. The stress is on the word undue, because in order to prove allegations of undue influence, the allegations must prove coercion. That's the test. It's not just persistence, influence. It's not just, over and over drumming it into somebody's head that this should happen or not happen. It has to be more than that. It has to be actual conversion, where you, in fact, take control of the other person's mind. It's a hard concept to get your head around at first, but you just have to think, here's a vulnerable person from whatever factor. Could be old age, it could be dementia, it could be a mental illness, it could be just they're a vulnerable victim in life. There's lots of them. And they're susceptible to what I call predators. They can sniff it out, whether it be sexual abuse, financial abuse, or any other type of abuse. These people can sniff it out, and they're very good at what they do. And it all usually takes effect behind closed doors, or at least out of sight, out of mind, and all that sort of stuff. My favorite example of a simple example of undue influence is a cult. Now, I don't do a lot of cult law. I wish I did, in fact, but I don't. They're few and far between, but some of them are legendary. You've got the Rajneesh down in Antelope, Oregon, where he had, I think, 93 Rolls Royces, and he would drive around and watch his workers slave away in the hot sun, all for free. And then there's the, the group sex and the this and the that, all at the whim of the Rajneesh a cult leader. Jonestown, let's all drink poison and commit suicide by the hundreds. These are the legendary cults, but on a smaller level, there's cults within religious denominations, secret organizations, probably even online organizations, because the latest that I'm sort of starting to see in the realm of undue influence are romance scams, where basically, usually men, but often women as well, take advantage of the lonely, and usually invariably for financial gain, and then are off. So there's a lot of abuse in our society. I don't mean to sound cynical after 45 years of practicing, but the last thing you want to be in this area is naive. So a lot of what I'm going to talk about today are not so much about the law, but what to look for, what to be aware of. Wayne asked me to do almost a checklist of factors to be looked for and considered and weighed when taking instructions, all with the overlying theme of looking for possible undue influence. There's going to be a bit of overlap because I basically put together 3 lists and merged it into one. So if I do repeat myself, pardon me, but some of it does bear repeating. So once you have a situation where someone has taken over someone's mind by coercion, basically the law then deems that what the person is doing is not really his or her own free act. They might realize what they're doing. Yes, they're signing a transfer. But what they may not appreciate is the intention of, and underlying facts on which they are transferring the property. I'll talk about the Hicks case in a moment, in which I was counsel, and I'll give you a good example of what I mean by that. There are 2 types of undue influence. There's actual, and then there's presumed. Presumed occurs where there is a relationship, where there's a potential for a relationship of domination and dependence. Your classic caregiver situation. There's a presumed relationship of undue influence when something untoward occurs, such as a substantial gift or bequest to the caregiver. The onus of proof then shifts to the caregiver to explain that it was a gift and not made pursuant to an undue influence presumption. Then there's the actual undue influence. And actual undue influence, you have to prove the allegations of undue influence. And because it's a type of fraud, that's considered by the courts to be a very serious allegation. And if you fail, which quite often does occur, unfortunately as it is, you run the risk of bearing what's called special costs, where basically you pay for the other side's legal fees as well as your own. So it can be particularly onerous, and you really have to have a good case before going to trial to allege actual undue influence. If you're going to go to court on an undue influence case, it's better to have a fact situation where there's presumed undue influence by nature of the relationship of domination and dependence. The leading case on actual undue influence is called Vout, V-O-U-T, versus Hay, which occurred early 90s, I believe, and was a 7-0 decision of the Supreme Court of Canada. But here's the facts. An old man who died at 88 by being murdered had lived alone in the woods and had very few friends. He was a recluse. There was a young woman who had befriended him. She apparently was a housekeeper for a while. She had a friend of hers, the quote legal secretary, prepare a will, leaving everything to her, the young lady. The man signed the will, and shortly thereafter he was murdered. It was alleged that there was undue influence on him by the young woman who stand to benefit, but the Supreme Court of Canada said no proof. Sure, it's suspicious. Yeah, we don't like it, but you didn't prove it. 7-0, we decide you have no case. Now, that was a complete mishandling of the facts and judgment, in my opinion, but I don't count. But as a result of that, BC legislature brought in WESA legislation, it's found 6.5 years ago, under section 52 of WESA, it now states that where there's this same relationship of a potential for domination and dependence, then whether it be a will or a substantial gift, it used to be a difference between the two. You had to prove undue influence in a will, but there was a presumption of undue influence where there was a gift to a person in what's called a special relationship. That's this one of presumed domination and dependence. It now pertains to both a will and a transfer, and where that type of relationship does exist, there will be a presumption of undue influence, and the onus of proof will shift to the other side to, in effect, disprove it, or prove the gift, or prove the bequest. So far, the courts haven't followed much of that legislation, rather disappointingly, I think. But these cases are all very, very fact dependent. So it just change the facts ever so slightly and you've got a different outcome. I've put in the materials a few pages of excerpts from the reasons for judgment of a decision called Hicks versus Hicks. I was plaintiff's counsel way back in 1997. I won the case at trial and it was upheld on appeal. And basically the trial judge and appeal court set aside a transfer of land and a codicil in favor of one son of three, where the court found there had been undue influence. Basically, the facts were sort of like this. I acted for one Mr. Hicks, who worked at City Hall and I think was the type of person who would wear a suit and tie to take out the garbage. John Q. Citizen. His other brother was a total flake. He lived in communes all his life. He was basically a sponge. When his wife took the stand, in our defense, she said that he only paid $175 payment of child maintenance and all of their children's growing up. The court looked askance at him right then and there, but he was just basically a flake and a mooch. And he moved in with his mom 5 years prior and eventually and slowly changed the locks and cut her off from the outside. She already was blind. He unplugged the phone. He basically isolated her, which is something it's a real red flag in this area. And then went to work on her basically after living off her pension for many years. He went around telling everyone he could that his mother had given each of his two brothers a house during her lifetime, and that this current condo she is leaving to him because he doesn't have anything and he should get a house as well. So he told the nurses and the doctors and everybody to back up his lie because she had not given a house to the other two brothers and they so testified. So basically the lawyer who drafted the codicil never met with her. He took instructions from the flaky son and gave a letter saying, sign here, sign here. Didn't even tell her how to properly witness as was required back then. And that was the codicil. The transfer, he briefly attended at the premises and basically took instructions from the flaky son in the presence of his mother. And basically all she had was the condo. So she basically transferred all of her wealth to her flaky son by this transfer as affirmed by the codicil. And the lawyer was called to task by the court for not having ever met with her, taken instructions from her, and a lot of the things we're going to subsequently talk about. But basically found that it was a total lie and fabrication that he had been given a house and the other two brothers weren't. He went so far as to type up all sorts of forgivenesses of debts, etc., forgetting that his mother, of course, couldn't see, let alone type. And his whole case just amounted to basically a sham when really, really closely examined and cross-examined. So the court found that when my client questioned him and confronted him about, did you sign the house, or did you have the house signed over to you by mother yesterday? No, that's not true. She's dreaming. That just underlined the entire fabric of what had happened here. And the court found that what the mother did is, yes, she knew she was signing a transfer to her flaky son. She just didn't know that the reason that she was doing it was a false one based on what the son had told her and inculcated into her mind over some time. So that's an undue influence case. Again, it all sort of took place behind closed doors. It all had to be exposed, just like the bugs scatter when you tear up the floorboards. And I've also found that all of his friends and witnesses were just as flaky as he was. It leads me to conclude that birds of a feather flock together in this area. There are a lot of strange people in this world, as we've all probably met by now in our day-to-day affairs, and particularly when they come to see you for documents like wills. There's all kinds. But what I want to focus on today is when it should be suspicious, which leads me to the doctrine of suspicious circumstances. It's a good place to start in estate law in understanding what undue influence is. These are factors that the courts have over time found to be what's called a suspicious circumstance, and it can shift the onus of proof from the presumption that everyone is testamentary sound and that there's no valid reason why the will should not be upheld. When there are enough suspicious circumstances, maybe even one if it's significant enough, the onus of proof will shift and the courts will look at the matter far more carefully. So the word suspicious is just like it sounds. It's when it gives rise to some sort of emotion that something's askew, askance, perhaps illegal, immoral, whatever the case may be, but not kosher, as they say. Trust your gut instinct. I'll say that probably a few times today because it really rings true. In this area, if you suspect something is astray, it is. Invariably, it is on some level. It doesn't necessarily amount to undue influence, but on some level, if your gut goes, why is that? Question it, because you can't just holus bolus take your client's instructions as to what they want to do in the disposition of their wealth. Yeah, it's a free country. Yes, I understand that a person should be able to do what they want to do with their wealth, but we do have a Wills Variation Act. And quite frankly, I earn my living when people don't provide for their children. And when they do wills that on the face of it don't make sense or were signed and given, and instructions were given to what amount to what could have been suspicious circumstances to the will maker. So what you have to be prepared for is the client who comes in and presents rather well at first. For example, they have their shirt on their top and their pants on their bottom. I wonder how many of you do right now. They can talk very collegiately about, how about those Canucks, eh? Yeah, they look good, they sound good, but they can't answer questions that are put to you that are there to what's called probe the mind. So you have to start with just like, what's your name, where do you live? That is part of the total taking of instructions. In fact, I heard an orthopedic surgeon present a paper one time that 50% of their examination is done watching you get out of your chair and watching you walk into their examination room and sit down, and in the case of women, put your purse on the floor. They can tell an awful lot about just how you move and what you're going to complain about and all the rest of it just from observing that. And what I'm drawing the analogy here to is that you should look for that sort of stuff too. Who is your client coming with? Friend, neighbor, what's that about? Favorite child, you got to sort of really start from scratch and almost have a bit of a suspicious nature yourself, without letting on, of course, because these people have waited years to get their wills done, and you're going to do a darn good job for them. So in no particular order, these are circumstances that may be suspicious and that there could be possible liability for, to my favorite people, namely disappointed beneficiaries. I love the term. They thought they were going to inherit, and they're right pissed that they're not. And they come to see some bottom feeder like myself, who will try and attack the will. So, in no particular order, you've got instructions that on the face of it don't make sense. Or do they? Like, why would your client give all of their assets to somebody that the family doesn't even know? That may be a neighbor, that may be a caregiver, that may be somebody who's just passing through their lives, somehow finagles themselves into their will. This happens, again, particularly with vulnerable people, and it's happening, I've been seeing in the last few years with these romance scams, as I call them. When a gift is made to someone who is in a person of influence, like your lawyer, for example, your doctor, I've seen that. Caregivers are perhaps the worst example. And I don't mean to shame caregivers. It's just that they do show up in a disproportionate amount of litigation when it comes to this type of case. Quite often, they're long-time caregivers that are more than deserving because they put up with a lot of abuse for 20 years. But there's also the 85-year-old guy and the 25-year-old cleaning lady. And we've all seen and heard of these types of cases. And invariably, if it's the old, what does she see in him, and what do, you know, there's a potential there for undue influence. There's just no question about it on the facts. So leaving gifts to people that have no close relationship to the family is not just, it's more than just an insult to the family. There might be valid reasons why they're disinheriting the family, and if so, you should spell it out in a long, detailed memorandum and charge extra for doing it. But I had one just this week where the two sons are disinherited, and a charity has left $2.5 million, and it's a good charity, but I don't think the lawyer who drafted the will really, shall we say, cross-examined the deceased as to why this was happening. It just sort of leaves the two sons out of it and leaves everything to the charity. Where there's a division of assets that is unequal between children, you're just asking for trouble. Now, it may be the sort of wills variation trouble that I like, but where you've got one child who may have been very harshly treated, the old black sheep, or where you've got one favorite child who was being treated much, much better than the other, it certainly on the face of it doesn't amount to undue influence. But again, it's something that's suspicious, and you really need to satisfy your suspicion as well as ultimately thinking, what will the court think of this if it's ever examined? Why is he doing this? Where you've got new wills and or codicil, and they drastically deviate from the three previous wills that you've done for the same client, because you will run into this at some point in your careers. Some people change their wills quite frequently, particularly in latter years. The funny story is Halsbury, who wrote a complete encyclopedia on wills, Halsbury's on wills it's called, died without a will. So basically, you've got gifts. Don't draw wills leaving gifts to yourself. I mean, obviously one knows that. But if some clients do want to pay you either an excessive executor fee over maybe what you might be entitled to by law, or want to gift something to, and I do see this in the notary profession, I do see a lot of you being executors, and I do see some charge maybe 10%, or it's a gift of 10%, that's your business. I'm just simply saying it might be a much better idea to have somebody else draw that will, because on the face of it, that is a suspicious circumstance that would, if contested, throw a notice elsewhere. I very briefly acted for a doctor who received substantial gifts, as did his wife, from a former patient, and it went public and it was in the news and it was a scandal, really. It just looked bad. on the what truly happened is they became really close friends and were for years, but that still doesn't look good. And the doctor gave back all the money, and that's really what I was hard to do, is just, here's all the money back. I'm so sorry, it'll never happen. But it was really disproportionate in a way to what happened in true facts, but it looked bad. You got to beware of the beneficiary accompanying the testator. Um, the testator may want them to be there, but seriously, you can't allow it to happen, at least not for more than just pleasantries and perhaps some background information. It is far, far better for you to meet solely with the testator. Take instructions. If there's any problem getting instructions, note what they are, make notations about how you found capacity, and I'll go through a checklist of questions to perhaps ask them in a roundabout, not so direct way in determining what's really going on. If the beneficiary sitting outside is the sole beneficiary, for example, and perhaps ought not to be, or you question why they are. So we all sort of know that, but we all breach it. And I see it breached a lot. And I perhaps drew 800 wills myself in my career way back when. And I'm sure I had beneficiaries sit in the room with testators, but it was just bad practice. So try not to go there. There always had to be a very good reason for me to allow it. A very bad reason is to have the beneficiary do the translation. You really need to get a separate translator for that, someone who's totally disinterested, or perhaps even a professional if you don't understand the language. Seriously, also, you do not want to take instructions from the beneficiary. Again, it happens all the time. Beware the situation where my mom's in hospital and she wants to leave everything to me, and can you rush over there and get them? I don't know where my brother is. He's an awful person. And you do that. Again, commendable that you're doing it, but I've always taken the view that if you didn't have a will and you're in the hospital on death's door, well, so that's why we have an Intestacy Act. Don't rush into these things. It can often, backfire on you, but invariably you find yourself taking instructions from a beneficiary, etc. Now, that also leads into the whole issue of, if you're in any way concerned about somebody's mental capacity, then it is incumbent on you to get a medical opinion, which is, of course, always a delicate matter when you're questioning your own client's mental capacity. So it's a difficult matter to be tactful about. But if you do want to or need to get a medical letter about mental capacity of your client in order to draw a will, firstly, direct the doctor to what test. So you need to tell the doctor what the test for mental capacity is. And it's the old chestnut case of Banks versus Goodfellow. It's a very simple test. They have to know, what is a will. Most people can handle that. They have to know what assets do they own, and a pretty good approximation of what they're worth. They have to know who they ought to have considered in making the bequests under the will. For example, that would be family members. They have to know who they are and why they're not providing if they're not, and who they are. And lastly, they just have to be free of delusions that might affect the last three. Delusions rarely come up, so I'll just leave it. And so it's a very simple test. What's a will? What do I own? What's it worth? And who should I be leaving it to? That's it. So the test for testamentary capacity is not that high, but it's amazing how many people actually on any given day would have trouble with particularly the second question about what assets they have and what they're worth. So you want to look for any signs of alcohol and abuse. People, of course, hide it, some better than others, and it can affect your instructions. And you have to also look at anyone who's done anything rather hastily in life, rather like a very sudden marriage. particularly to somebody like a mail order bride or to a much younger man, if you're a woman or whatever. Just something on the face of it is very sudden, very out of the clear blue. And what is that all about? That raises suspicions. Um, there could be depression. There's a lot of depression amongst seniors. There could also be language barriers and disability matters such as hard of hearing and blindness. And those are just some of the suspicious circumstances. That's not an exhaustive list by any means, but when any of those matters arise, it can shift the onus of proof, as I said earlier. So when meeting with your clients for wills, I suggest take your time and charge accordingly. Charge by the hour. Don't quote this $200 for a couple or whatever the case may be these days. I'm not suggesting in any way some sort of price competition. I'm simply saying charge your hourly time and do a proper job. I've said this to your gathering many times over the years. You really need to take the time to probe the mind. And that is by asking questions, not having a checklist. Checklists are good. But I recently had a court case where a notary used a checklist in going to somebody's house. And it seemed apparent to me that most of the instructions were given by a female who lived in the house, but was not a spouse. And that's what the case was about. Was she a spouse? Now, in the will, she was referred to as a spouse. The notary put her down as a spouse. This information came from the woman. All of his medical records from him were that she was not a spouse, she was a tenant, and that was the relationship between them. So no questions were really asked. It was just a tick, tick, tick on the checklist. And I found myself arguing that, yes, the notary went through a checklist, but it seemed very cursory and no notes as to how, what the relationship was, why is he bedridden, what's the nature of his illness, how much does he drink. All of these things were readily apparent, but were not asked or pursued. And there really was an opportunity there for undue influence, because even though they had lived together for many, many years, it was not spousal. Okay, so the probe the mind is not as difficult as it sounds. It's just asking them the questions that they should know the answers to. After you get past the name, address, etc., a good place to start is the date of birth and the place of birth and all the things that you need in terms of information for a will's notice, and then move on to detailed questions about assets and income and living expenses and so forth. And if the client has no trouble with that, then there's really no problem in terms of capacity. This is really where it all comes down to. They may, most people do know who their children are and who they're going to inherit and not disinherit, but that is sort of another matter. That usually leaves the realm of mental capacity and sort of enters the realm of possible undue influence if one is substantially benefiting more than another child, for example. So you really want to know what their living conditions are like. Who do you live with? How long have you lived alone? Do you live alone? Do you have a tenant? How will you live with a child? What's the relationship? Do they pay you rent? Do they this, do that? What do they do for you? You have to sort of go into all of that stuff, because often, for example, if a parent is living with one child to the exclusion of others, that child invariably tends to end up getting either a life estate in the house or a substantially greater share of the house. What you have are the other children going, but he or she lived there all their lives for free, never paid rent, never paid for anything. Mom paid for everything. All they did was watch TV together. You know, you get this sort of stuff from the other side of the family, whereas the one child that it tends to inherit will portray themselves as a saint who gave up their life to live and take care of mom. How could you question that? So you want to know that type of living arrangement, what type of mobility they have. You want to be aware of any possibility of being isolated, because that is really one of the key factors in undue influence. I think we've all felt a bit isolated due to the coronavirus, but that's not what I'm talking about. Isolated is when literally somebody phones to talk and, oh, they're sleeping right now. Change the locks, never answer the phone or the buzzer. Just make yourself generally unavailable, at least that is the perpetrator, making the victim inaccessible. You want to know about banking, who does it? You want to know if people have asked for substantial gifts. Have you given any substantial gifts? Obviously, do you intend to give substantial gifts in your will, and why? If it's to grandchildren, it could be fair enough, but if they're disinheriting a child in favor of the grandchildren, again, it needs to be canvassed, possibly primarily for the Wills Variation Act. But I have a surprising number of cases where it's alleged that a grandchild moved in with granny and basically took over their lives to the exclusion of the previous generation. So it is something that I do see on occasion. And so I would red flag that type of relationship. You want to sort of question the abuse factor. People don't admit to being abused. They hide it. I've had any number of cases over the years where two sisters are both sexually abused by the same person, yet neither sister tells the other, and they find out perhaps in their 50s that it occurred to them as well. Meanwhile, they've gone all through life feeling victimized and at fault and all the rest of the shame that comes with such type of horrible abuse. So it's a very secretive sort of world. Financial abuse is no different. Some people are in effect blackmailed or being victimized, not just by on the telephone or the various frauds that are around, and there's a lot of them, but just feel victimized in general, given the circumstances in 2020, and the family doesn't call and come, and they're alone, and they're just more vulnerable people these days, and it's sort of accentuated by the virus. And I know back in March, people were doing many more wills. I think it's tapered off, but there was that sort of, we got to get our will done mentality for a while, which is good for business, but it can also be another point of letting your guard down because you have a volume to deal with all of a sudden and you want to crank out those wills. You shouldn't perceive wills as any sort of loss leader, that they're going to come back to you and you're going to probate the estate type of mentality. The lawyers went for that for decades and decades. It doesn't work very well. We're told not even to keep the wills and to have the clients keep them themselves, but I digress a bit. I'm just simply saying that if you're in the will business, it's better to do a good job and charge accordingly and go through the rigmarole of what I'm telling you about today in terms of ask for this and look for this and beware of this. Ultimately, the client is your client and you owe a duty to protect your client. So you're really just doing what I call due diligence and asking all those probing questions about their lives. Again, stressing it's confidential. You'll have lots of clients not want to tell you what their assets are, but if that was the case with me, I'd say, well, I'm sorry, I can't draw your will. And not only what assets do you own, how are they registered? Are they in joint tenancy? And, you can't accept the client's word for anything. You have to do land title searches, and you may well be negligent if you don't. You have to do corporate searches, and you have to just basically double check what clients tell you, unless they've given you a document that you can, take a copy of or keep in order to substantiate your file. When you ask all these probing questions, the whole point is to keep notes. I mentioned a few minutes ago about the checklist. Again, checklists are great to follow, not actually to fill in or anything, because they're not meant to be wordy. You need more than just a few words of observation in order to what I call pass the professional test of giving good legal advice. And I'm going to talk about what's required in a few minutes for what is required for good legal advice. But having said that, um, when you have no notes or very few notes, and you find yourself on the witness stand saying, well, gee, it was my invariable practice to ask them their name, but you made no notation of it. And I've seen that. I don't mean to be facetious. You look bad. So by all means, take more notes. I used to always type, I still do. For 25 years, I've typed my notes, and then I've given the clients a copy of my typed notes with the words, make sure I got it right. It sounds so simple. It is so simple. As far as I know, I'm still the only one who ever does it. You're a lot less chance of getting things wrong when you do that. And in wills, it could be just the spelling of names. It's very easy to happen. You got to check out that whole abuse thing. Have you been threatened by anybody at any time? Have you been influenced by anybody at any time? You can go through it in sort of a matter of fact point of view, but really you are looking for some sort of reaction, because a lot of people do wills, I think, when it's not really what they want to do, but it might well be what the other party in the room with them wants to have done, often a co-partner who is having his or her will done at the same time. If there's a problem getting instructions, then I think it's appropriate to speak to outside third parties to verify what's going on. And you should just simply get your client's instructions. Can I talk to your daughter, sister, brother about this? And again, you're just verifying what they've told you. The red flags are basically just a continuation, and a specific paper here on red flags. It's basically more of the same of what we've been talking about. So I don't want to overly repeat myself, but the prime examples that I look for in whether there is something that really doesn't fit here is a simple smell test. You've all had many life experiences in various fields, and many of the notaries that I know have come to notarial work after a career in another field. You've met shysters, you've met psychopaths, you've met charmers, you've met all these people in life, and you have some opinions. And my simple advice is trust your gut instinct. That suspicious factors that we just talked about, they exist, you'll see them. I'm simply saying check them out and charge for it, because you're going to have lots of people come in to see you who are going through some sort of crisis in their life. If someone has just died, for example, a long-term spouse, it may well be appropriate for them to come in with their son and their daughter, and that mom wants to do a new will and leave everything, to us equally, sort of thing, because that's a normal sort of situation. I'm talking about the situation where that same vulnerable person comes in with a stranger, a neighbor, one child of several, and so forth, and wants to leave everything to that person. And I'm talking about both in transfers and in wills here. You have to be equally as guarded for a transfer as you do a will, because it's really the same thing. And by and large, the transfer is transferring most of the accumulated assets that a person has in the way of a house or property. And then they'll invariably be taken to the bank or investment counselor to do the same with their other investments. You've got to also be aware of cultural differences. Some cultures prefer men over women, for example, and some religions have their own, this is the way it is. That may well not be, and probably is not, the law in Canada. I was counsel on a case that made a lot of press last summer. It was in the press for, I think, 12 days. It was called the Litt decision, L-I-T-T. It was a $12 million farm, and there was a disproportionate amount given to the 4 daughters as opposed to the 2 sons, and it was a 3-week trial. And the daughters prevailed and got an almost equal share. And the law was, it wasn't new law, it was simply reinforcement of existing law, that the culture of this country is not the traditions of your culture in the old country, and that here, unless there's a good reason, the sexes should be treated equally. You should not be disinheriting a son or daughter because they're gay, or that they've changed their religion, or you don't prefer their lifestyle. This is British Columbia and it's 2020, and the courts have a pretty liberal view of what's allowed to disinherit somebody and what's not. So again, it's a little bit off topic from undue influence, but it's a lot on topic for what's going on. Same with sexual bargaining. There's a lot of cases on sexual bargaining, usually related to trying getting out of a quick marriage, an improvident marriage. Often there's an inordinate difference in age and wealth. And usually it smells that somebody has taken advantage of the other, but it's difficult to get out of marriages. It's not that simple. The law, perhaps not surprisingly, finds marriage as a very simple contract. And perhaps it is a very simple contract, but it's one that's easy to get into and very hard and expensive often to get out of. So I'm seeing these romance scams, and people are drawing wills, leaving and giving assets and monies to all sorts of strangers that they really don't know, all in a wink and a prayer that they're going to come here and have a terrific romance and happiness and so forth. And I think, again, it's just a sign of the time. It's another example of internet abuse and intrusiveness, and people find out just enough of information about you to pretend to know somebody who knows you, and whatever the scheme might be, there's 100 of them, or if not more. And so it's just something, again, to watch out for in terms of the pandemic of undue influence. Again, I want to stress that there's just much more abuse out there than anybody really could believe. Sexual, financial, emotional, I sort of heard it all. It's interesting, it's just prevalent, and it's shocking, and the law is not very well prepared to deal with it, quite frankly. Undue influence is, again, we're afraid to allege it because if we fail, the special cause can be punitive, and there's often not very much evidence. So again, you're the front line, and I think it's increasingly a decreasing front line as more and more people learn that they can do their own will, and who needs a lawyer or notary? You just write out a piece of paper, and then this provision of West will fix it all. And that's actually almost true, but it leaves a lot of room for fraud and undue influence and lack of capacity, because there's really nobody such as yourselves on the front line scrutinizing this. So invariably over time, there's going to be more and more undue influence, particularly with the advent of electronic wills and the distance involved in witnessing a video of somebody executing a document. You don't really know what's going on in the background. That's the problem. So again, it's another step removed. Yes, it's more convenient. Ultimately, it's really good for my business. So you also need to be aware of impaired mental functioning. It could be the sudden onset of confusion. Happens a lot. Could be a stroke. It could be just Alzheimer's peering its head. It's been there for a while. Typically, when you've got an Alzheimer's situation, the glowing evidence is poor short-term memory loss. Okay? What were we talking about 5 minutes ago? I can't remember. Oh, undue influence. But that's the sort of thing that people will display, repeatedly telling you the same thing over again. I'm doing that now. It's awful, but I'm not yet demented. Disorientation, difficulty handling their finances. A lot of people have never balanced a checkbook, never written a check. They've always relied on, say, their spouse, for example, their financial advisor, and so forth. And again, these people are very vulnerable if they can't do their own finances. A lot of personal impressions can be gained just by watching their body language. Do they smile? Do they act appropriately? Do they show any signs of depression, anxiety, and so forth? And if they do, if they're showing a bowed head and they can't look in the eye and they can't get, make up a decision, that's something to explore, because they may well be suffering, and maybe they're against their better judgment to provide a will. Some people just have continuous speech, poor judgment, inability to concentrate. I know I sound like I'm describing President Trump here. Distressed, overwhelmed. There's a lot of these sorts of emotions displayed in a lawyer's office or a notary's office, because often it's the first time anybody's ever been there, and they're not particularly relaxed, and all sorts of emotions can be either suppressed or come to the foreground. But if somebody cannot answer open-ended questions, not detailed questions. It's about, in the sense that it's a physics exam, it's about their life. These are questions that everybody should know readily. What's your social insurance number? What's this? What's that? Now, if they can't remember their social insurance number, it doesn't necessarily mean they're demented and they don't have capacity to do a will. It's just a checklist. And it's an overall, you form the conclusion, yes, they knew what they were doing, in the sense they knew what a will was, they knew how much they had and what it was worth and where it was, and they knew who they should have been providing for, and they didn't think any of their children were the devil as per a delusion. Then they have capacity to draw a will or to transfer a piece of land. But if they're hesitant or don't know any of those factors, that's when you really need to probably say no or get a medical record. Sometimes the best thing you can do to save yourself grief in the future is to simply say no. I say no a lot. I find it odd that most lawyers can't say no. They say no all their life when it comes to everything else in life, but suddenly it's like to take a case, not take a case, they have to do it. So you also see the overly helpful influencer. Often the person who stands to benefit is just so helpful. I had one where the caregiver was so helpful to the nurses in hospital that they basically could ignore that patient. When they came to trial, each nurse practically wanted to spit on me for contesting the will against this lovely lady who stole everything from the old man. People who insist on being present during the interview, people that contact you all the time. How's it coming? Like, where's it? This sort of stuff when they're not the client. So again, it comes back to the gut feeling, taking notes, keeping notes, asking lots of questions. What needs to be done when it comes to the quality of your legal advice was decided 4 years ago by the Court of Appeal in the Cowper, Smith, and Morgan case. It's in the materials. There's 5 criteria. Was the person benefiting from the transaction also present when the advice was given? That's a no-no. Whether technically you were acting for a client, you still took instructions from somebody else who typically might benefit, that's a no. In a situation where the transaction involves substantially most, if not all, of somebody's lifetime accumulated assets, you have to look into whether you're aware of that fact and whether you discuss the financial implications of doing that in detail with your client. 4, whether you inquired as to whether the donor discussed it with the family and that the family basically okayed it or took a position to the contrary. You should know that. And 5, whether you discussed other options. For example, you get a situation where a parent wants to transfer the house into joint tenancy with a daughter or son. Bad idea. There's all sorts of problems that can arise as a result of that. But even if the client were adamant, you should still reserve a life estate and transfer it to the child, but reserve a life estate in favor of the adult. That way it avoids any questions about undue influence that may arise when the other children come along and contest it. So those 5 criteria are the bottom line. And the bottom line basically is that you have to ensure that the gift is right and proper in all of the circumstances, and that the client totally understands that to be the case. And you have to go the extra mile of explaining the implications of what's being done and other options that might be appropriate rather than doing what the client wants to do. Because quite frankly, clients don't always have their best interests at heart. This particularly is the case with parents who typically view their children with rose-colored glasses, despite lots of evidence to the contrary, and they want to do things that are just not advisable. I think you should look beyond the Wills Variation Act as a possible remedy for doing these types of instructions, carrying them out that might be inequitable to other family members. Unless you've got really strong evidence, there might be more suspicion of undue influence here if you scratch the surface than you may well think. As I said a moment ago, there's far more of it than anybody could possibly imagine. It's just that it's really hard to understand. I've just completed a paper on electronic wills today, and I only spoke of them briefly in this paper by reason of the fact that they will give rise to more suspicious circumstances in the future. But the leading case in British Columbia was a little WordPerfect file called 2017 budget. And it basically said, get a will done this year, split 5 ways, names 5 people, and no executor, unsigned on the computer, and that was found to be a valid will. That followed, although it didn't necessarily follow, it referred to a couple of Australian decisions where an unsent text message was found to be a valid will and somebody committed suicide. They found that it was written that day, just moments before the suicide, and the unsent text message, it was sort of everything to my brother sort of thing, very vague, very unspecific, was found to be a valid will. That is the future now. These electronic wills have been allowed for 6.5 years, 5.5 years now, and they're just starting to come to fruition before the courts. I know many of you are executors, and it just creates another onus on you as executor to not only go through diaries and papers, but also go through computer file folders, searching for a document that could be a will. You're obligated to bring forth any such document to the court for the court to decide. The problem is that I probably wouldn't have thought that last case I just referred to was a will either. 2017 budget, it mentions something he's going to do that year, but he never got around to doing it. Still found to be a valid will. So that gives leaves a lot of opportunity for undue influence, which may or may not have anything to do with your office, but it just seems to be where society's headed these days. People are getting more and more educated. They know it's hard to prove. They know there's very few witnesses. They think if they can get away with it, they're going to get a good share of the settlement in any event, and they might well be right. I'm just saying that there's a lot more of it to be aware of than perhaps you ever suspected. I note the hour. I think I'm right on time with 1 hour. And I think somebody there is allowing questions for a few more minutes. Hi.
Excellent. Thanks so much, Trevor. Yeah, we've got some good questions and quite a few have been voted up. So we'll start with, can you comment on what potential opportunities you foresee e-wills will bring for you in the imminent future, particularly with regards to remote execution and undue influence?
Yeah, I think I just was touching on that actually. I think they're a great boon for my business, which is basically as a bottom feeder to pick apart wills and attack lack of capacity, allegations of undue influence and so forth. And I think it puts an extra onus on you will drafters to ask people who are about to sign documents by video links, who's with you? Who have you discussed this with? Has anyone tried to influence you? Who have you told about the will? I think it's incumbent on you now to ask those sorts of questions, as well as going over the terms of the will with the client, but perhaps just be more scrutinize a little more carefully than you would have in the past.
Perfect, thank you. Can you please comment on elderly clients who are drafting a will or power of attorney and may not be on top of their finances, but appear to be mentally capable, just never bothered themselves with their own finances, and want to ask their children who manage their finances for them? Is it okay to send your client away to review their finances and come back and see you?
Yeah, it comes back to it's one of the requirements for mental capacity is that people should know what do they own and what is the value of it. Approximately. Things do go up and down in value. I appreciate that. But I, as probably you have, encountered an elderly person who bought her house in Vancouver for $2,500, $50 for the lot, and $2,450 for the house. And when I told her it was worth $1 million, she had no idea what I was talking about. Now that gives rise to like a capacity issue, although she knows she owns her own house. So again, I think you have to tell the clients, just take a moment, familiarize yourself with what you've got. They've probably got 2 bank accounts in a house. That's what most people have. So it's an excuse on their part. I think they should know what they have, and you need to know what they have in order to decide if what they're doing is prudent.
Great. I have heard in a different seminar on undue influence that capacity letters from doctors are not as helpful as we would hope in defending your decision to proceed with drafting the will or power of attorney, etc. What are your thoughts on that?
Well, that might be true because usually you're asking the doctor, is this person mentally competent to do a will? You're not asking the doctor, is this person more susceptible to undue influence from others? Which I might very well ask, say, a geriatric psychiatrist who I'm having review already obtained medical records. So it's actually a practice hint that it would be a far better letter for the wills drafter to write to the doctor to ask both questions, because you don't necessarily have to be mentally infirmed to be unduly influenced by another person, although generally speaking, most are. I go to the cult situation. These people are not demented, they're just very vulnerable for other reasons. But most people are demented, so it might well be a good practice to ask, 1, does this person have the mental capacity to do a will? And 2, is this person more susceptible to the undue influence of another person?
Perfect, thank you. If the willmaker discloses having schizophrenia but is behaving rationally, should you still get a medical opinion regarding capacity?
I don't think so. If it's a question of taking their meds, as I understand it, a lot of people live with schizophrenia and operate very normally. They might have, some personality quirks, but lots of people do. And the courts recognize quirks and eccentricities, as they call it. But if they know what a will is and what their assets are and who they should be providing for, they've got enough capacity to instruct a will. And even patients who have been declared incompetent under the Patients Property Act and have a committee appointed for them can very well, in certain circumstances, still have sufficient capacity to draw a will. I just blogged on that topic last week.
Perfect, thank you. The next one's long, so I'll read out the scenario, but it has been voted up, so it's popular. I've had situations where a couple comes in and one has children from outside of the marriage. Clients want to leave everything to each other, then to the children from outside the marriage. I've advised clients that children could contest the will at the point where the parent dies. Clients tell me all their assets are in joint anyways with their spouse, so there's nothing for them to contest. Can you confirm that children can contest joint assets with a step parent when parent passes away?
No, the only people who can contest a will under the provisions of the Wills Variation Act are spouses, either common law, same sex, you got to live together in a marriage-like relationship for 2 years or get a marriage certificate, and natural children or adopted children. Stepchildren don't count, neighbors' kids don't count, cousins don't count, only those criteria. So yes, it's true that the first set of assets are in joint tenancy. So assuming the natural father dies first, yes, the surviving spouse, the wife, would inherit, and she has no obligation to her stepchildren and vice versa. But ultimately, one parent is going to have all the assets in his or her name, and so the question still then does arise. And if you're not providing for children of a marriage, you do have to have very good reasons why not. Or put your assets outside of the estate so that they can't be attacked.
Great, thank you. What would you recommend in a situation where the will maker is disinheriting a child, but they don't want to write a note or letter of memorandum? Also, what if they already typed up a detailed note that they have signed and sealed? Should we ask for an electronic copy?
Yeah, I think you want to know that. You may not need to take possession of it, but you'll want to at least canvass with your client that if he or she wants to draw a memorandum explaining to the court why he or she is disinheriting a child or giving a lesser, award or bequest, that it be set out in writing and be in somewhat detail, that it not be malicious, that it be accurate in terms of facts, and it can be very helpful in upholding the will. Otherwise, if you're silent about it, the court assumes that you really just didn't have anything to say about it. If you simply have a one-liner saying, I provided enough in life, so that's enough, that isn't the law. It might be the law in other provinces where I see an attitude in Alberta, like I raised you, I clothed you, I fed you, I educated, now you want my assets? Here in British Columbia, the attitude's different. Poor baby. So the more information you have, the better to protect your client.
Okay, perfect. For unequal division in a will, is it appropriate to have client prepare their own letter memo as opposed to member preparing the memo so it's in the client's own words?
I think both. I think the client will save money putting it down in his or her own words, but the drafters should not just parrot the words. They should put them in slightly better context and, things that lawyers and notaries do in drafting letters. And again, charge accordingly for it. Get away from this mentality of so much for a will. Charge your hourly rate and take the time to do it properly. It could make all the difference in having a properly drawn memorandum. It makes my life more difficult when you do that. I know that. Particularly where people have been estranged for a long, long time. I've gotten about 4 cases this week where people haven't seen their mother or father for between 20 and 40 years. The question is, why? You'd have one side of it written down if you had it. It probably won't jive with what the client's going to tell me, but at least you have the parent's version of what happened. Anyone?
Can you point out some good case law referring to Section 62 Lessa?
62 or 52?
6-2.
Not off the top of my head, but I have 1,400 blogs on my website. So seriously, if you type in Section 62, I know I've done a blog on it, and it'll bring up some cases on it. There's almost every topic you can possibly think of on my websites. And if you have anything else you can think of, send it to me, because it's hard coming up with new topics all the time after having blogged for 10 years.
Great, thank you very much. That answers our questions, and I'll pass it back to you, Chad.
Thanks, Trista. And Trevor, if you don't mind, one just came in that I'll refer to. It says that you touched briefly on testator wanting to give grandchildren rather than children, meaning give to them. So can you share further thoughts or guidance on this?
Sure. Nothing will divide a family faster than skipping a generation and leaving it to their grandchildren. It's the sort of nasty thing that some testators love to do, and they cackle in their grave and supposed to roll over in it. They know that they're putting you in a difficult position where you have to sue your own children. The law's pretty clear. Again, I blogged on this about 3 months ago, that you're not, if you leave something to your grandchildren and not to your children, you're doing so at your own risk, because you're not benefiting your children in any event, you're benefiting their children. So you're not avoiding the will's variation action by doing that. You're just causing one parent to sue their children, which is probably what they want to do secretively anyways. Some people are just like that. Some facts might bear it out, but there are good children and bad children and good grandchildren. I mean, that it may well be warranted, but as a general rule, I'd be aware of it.
Okay. Trevor, Todd, thank you so much. I found that very, very interesting. Some comments coming in too on what a great session it was. Really appreciate you taking the time this Saturday to present to notaries and give the group the benefit of your experience. Certainly much appreciated. I was a little leery when Trista said, well, he hasn't got a PowerPoint. He's going to talk to us for an hour plus.
No problem.
Wow, it was very engaging. So thank you.
Well, thank you so much. I just miss an audience.
Yeah.
I miss the convention. I've always had fun at your convention. So maybe next time.
Thanks for that. Let's hope so. And we look forward to seeing you there when that can happen. And to notaries who are waiting for the next seminar, that will begin at 2:30 promptly. That's the practice advisory line. And so we'll look forward to that. No need, I think, to log off. If you want to step away, folks, have a quick break, and we will begin promptly at 2:30 p.m. Thank you again, Mr. Todd.
Thanks. Bye-bye.